10 costly estate planning mistakes. Did you fund your trust correctly? Are your beneficiary designations up to date? Is your last will and testament 30 years old? These are the common estate planning mistakes and more that we see every day in our estate planning practice. Number 1, improperly funding your trust. If you're going to go through the expense and the long amount of time and work it takes to get your estate plan done correctly, then you must fund it. And you've heard me talk about this in other videos, that funding means changing the title of your assets to the name of your trust. So instead of just Joe and Sally owning the house, it's Joe and Sally as trustees of the Joe and Sally Revocable Living Trust. This is the number 1 mistake that people make all the time.
You made a serious mistake.
They forget to fund their trust. Not only their real estate, but their bank accounts, their cars. Anything that has a title should be funded in the name of your trust. Number 2, not having your beneficiary designations up to date or having unintentional beneficiary designations. And this happens all the time. The best example, and you've heard me talk about it in other videos, is when somebody starts a new job, like back in the 70s, like your parents did. And when they first started their job, they were single. They weren't married. They didn't have any kids. So they probably listed their parents as their beneficiary. And then as time went on, they got married, maybe they got a divorce, maybe they got married again, maybe they had kids, and they never updated those beneficiary designations. Or maybe they updated them to their first spouse. If it was your father, maybe he put his first wife as the beneficiary designation. Maybe he's married 2 or 3 times since then, and that first wife is still named as the beneficiary. And unless he's changed it, it doesn't matter who he's married to now, that first wife is still gonna get that bank account or that retirement account or that insurance policy, because that is who he is named as his beneficiary. Number 3, insufficient cash to pay for gifts in your estate plan. And you might be wondering, well, I want to give $10,000 to each of my children. But what if when you die, you only have $8,000 left? Then how do you split up the estate? The better way to do it is to give everybody a percentage. If you have 3 kids, give each one of them a third. Or if you have 4, give each one of them a fourth. But when you make a specific dollar amount, you may end up leaving somebody else out. Let me give you an example. Somebody has 4 kids. The first 2 kids, he gives them $10,000 each. And then the other 2 kids, he gives the remainder of his estate. They're gonna split it 50-50. But when he dies, if he only has $12,000 in his bank account to his name, all of his assets add up to $12,000, then he can only give that first one $10,000, the second one $2,000, and then the other 2 get nothing. The better way for that person to have done it is just to say a percentage. I give a fourth, a fourth, a fourth. And then that way, you always guarantee that at least something is going to go to the people who you want the money to go to. Number 4, forgetting to update your estate plan after you get a divorce. Now, this is gonna depend on what state, what jurisdiction you live in. Most jurisdictions, not all of them though, that's why you need to check, have language in statutes that when you get divorced, that divorce nullifies your estate plan as to your previous spouse. So if you were married and then you pass away, your husband or wife cannot still inherit from your estate. But not all states have this language in it, so it's very important that if you've done your estate plan while you're married, that you update it after you get a divorce, so you make certain that your assets go to who you want them to go to and not to your ex-wife or your ex-husband. You hear me always say, do you want your assets to go to your children, or do you want your assets to go to your ex-wife's new husband's children? So make sure you update everything after a divorce. Number 5, is your last will and testament old or lost in a pile of junk and papers? If that's the case, then nobody's gonna be able to find it. If you have a last will and testament that is old and names people who aren't even alive anymore, that's gonna create a lot of problems when it comes to probating your estate. If it's lost where nobody can find it, then that's gonna create an even bigger problem, because the estate will probably be probated under the terms of your laws of intestate succession. And that means that people who you didn't want to get your assets might end up getting them. So if you're in this situation, it's time to clean up your mess and make sure that your last will and testament is up to date. Number 6, poor communication on who gets what. You've heard me talk about this in other videos, where mom or dad says at every family celebration that her house is gonna get split 3 ways. But then in her last will and testament, she only gives it to one of her child. Well, that's a problem, because under that last will and testament and under the probate procedure, if everything else is done correctly, that one child is going to get that house. So don't be afraid to talk to your kids about who gets what. And that way, there's no question when the time comes, and you reduce the risk of them fighting and spending money unnecessarily if they just know what's going to happen ahead of time. Number 7, skipping the formal execution process. This happens when people go online and they get a last will and testament that they download for $19 or $49.99 or whatever. But it also happens when sometimes people ask their attorney to draft a last will and testament, and then they tell them, I'll just sign it myself at home, and not going to sign it correctly. Under most states, under most jurisdictions, there is an actual way to sign a last will and testament. And it depends on your jurisdiction, but you usually have 2 witnesses and you usually have a notary there, and they all have to be independent people. You can't have the child that is going to get everything be a witness for your last will and testament. That right there doesn't look good, and it's going to be an easy way for somebody to contest that last will and testament. So if you're going to do a last will and testament, make certain that you execute it correctly and formally in accordance with your state's laws and regulations. Number 8, drafting your own last will and testament or drafting your own legal documents. Nowadays, it has become really easy for somebody to get online, get on a computer, get on the internet, and download a last will and testament, download a trust, download an irrevocable trust, whatever the document is. The key, though, is knowing how to fill out those forms correct. And that's the other issue. They're forms. And generally, these companies who do them so that they work, hopefully, no matter where you are in the country. But every state has different laws and regulations, and just downloading a last will and testament off the internet may not work in your particular jurisdiction. We have had to fix a lot of these last will and testaments that were downloaded and end up costing the family and the estate thousands and thousands of extra dollars because the language in there was not correct or was very ambiguous to their exact situation. So if you're going to get a last will and testament, at least speak with an estate planning attorney to see what your options are, and then you can proceed at your own caution. Number 9, along the lines of the last 2, relying on your neighbor for your estate plan. And you might think this is funny, but we actually see this on a regular basis. Somebody in the neighborhood will go visit with an attorney and get an estate plan done specific to them, specific to their circumstances. And then the neighbor down the street doesn't want to go and pay because they realize how much it costs to go to that attorney. So instead of paying for their own estate plan, they say, can I just have a copy of it? And then they scan it. Maybe we have literally seen where they literally have just crossed out the names and put their names in place. Guys, in most cases, this is not going to work. There are formal requirements for executing documents, and if you just start scratching stuff off or putting liquid paper on stuff, then it's not going to work the way you wanted. And the language that's in your neighbor's estate plan is probably not going to be good for what you want to do with your estate plan and your assets. Number 10, not doing anything at all. We get calls all the time from people who say they don't care what happens to their estate plan after they're dead. And I think this is hilarious because they called us, right? They called us for information about an estate plan, and then the first thing they tell us is that they don't care what happens. But there is a huge danger in not having an estate plan on several different levels. The first one you hear me talk about all the time, and that's incapacity planning. If you don't have a plan in place, I believe an estate plan is most important about how you are going to be protected during your lifetime. And if you don't have a plan in place, that means your family is going to have to go down to the courthouse and visit with a judge that they've never met before, and they're going to have to give testimony and explain to the judge why they need a guardianship over you. Not only that, that is going to cost them thousands of dollars. I call guardianships live or living probates. They cost almost as much as a probate, but sometimes I think they are more difficult for a family to go through because the person that they are talking about is still living. They're having to make decisions for that loved one. And then the next level is what happens to their assets after they pass away. If you don't have a plan in place, then your state most likely has laws of intestate succession that says exactly what's going to happen to your assets. And you may not like the distribution that the state law says. We have literally done probates where they thought all the money was going to go to one person, and because there was no plan in place, it went to 18 different people. I kid you not, we had one where there was hundreds and hundreds of heirs. So you may not care where your estate plan goes, what happens to your assets, but don't create headaches and turmoil for your family later on. Get an estate plan in place to protect you during your lifetime and protect your family after you pass away.
I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.